Good evening, everyone. Welcome to the fourth virtual conversation and the Representation Matters program, Who Gets to Vote? A discussion of voting rights today. This series is hosted by the George Washington Carver Museum and Cultural Center, a cultural institution dedicated to honoring African American heritage, arts, and culture in Arizona, and Arizona Humanities, the Arizona affiliate of the National Endowment for the Humanities. Since 1973, Arizona Humanities has supported public programs that promote understanding of the human experience with cultural, educational, and nonprofit organizations across Arizona. This program was funded by the Why It Matters Civic and Electoral Participation Initiative, administered by the Federation of State Humanities Councils, and funded by the Andrew W. Mellon Foundation. Our speaker this evening is Dr. Joshua Sellers, Associate Professor of Law in the Sandra J. O'Connor College of Law at Arizona State University. Before we get started, for the best viewing option in this webinar, you'll want to be in the full screen setting, and you can adjust that in the top right-hand corner of your screen. If you have any questions during Dr. Sellers' talk, you can add them to the Q&A, and the Q&A button will be at the bottom of your screen. We'll also have the chat enabled, so you can add any comments or chat about the talk as Dr. Sellers is giving his presentation. And Dr. Sellers is going to pause once or twice and after his talk to take questions from you all. So feel free to add any questions you might have as they come up. And today's session is being recorded, and that recording is going to be made available on the Carver Museum website, carveraz.org, and we'll also add links to direct you there from our own website, azhumanities.org. Okay, Dr. Sellers, do you want to take it away?
Well, thank you, Julianne, for that introduction. Thank you to Arizona Humanities and to the George Washington Carver Museum and Cultural Center for arranging the program. Thank you to the Andrew Mellon Foundation for sponsorship. And of course, thank you to all the attendees who are here tonight on a weeknight at 6 o'clock nonetheless. So I appreciate you being here and look forward to engaging with you. Let me echo what Julianne said. I welcome questions. When I do these public addresses, I like to have them be dynamic. And so I hope that you will participate via chat or Q&A. Let me share my screen with you. Okay, so if you're anything like me, I wake up in the morning and typically we'll look at the New York Times, look at the Washington Post, look at AZ Central. And every day it seems there's new information, new stories about election law, litigation, and voting rights issues that are happening all over the country. Certainly we know that's happening here in Arizona. And so one of my goals for this presentation is to try to provide some historical context for that litigation and give you a sense of, what is happening here, what's animating this, and how are courts likely to think about these issues, because we just have this rash of legislation that is arising all over the country, and I think a lot of people are confused about what's permissible, what's not permissible, and what this really means for our representative democracy. So let me start by just providing a little bit of historical background on the right to vote. And given the limitations of time, this will of course be a somewhat brief overview. But I want to start with an observation that surprises many people. And that is that the US Constitution, right? This is the model of democracy for much of the world, right? This is the world's longest surviving constitution. It's also very brief, by the way. It's a very short constitution. I think it's the second shortest constitution in the world. It contains no affirmative right to vote. Again, that's surprising to many people. There's no language that you'll find in there that guarantees us the right to vote. And in fact, in its original form, before the amendments were added, it had very little to say about the right to vote and very little to say about the political process generally. And I think people are unaware of this, and they tend to think that there's something in there that provides this right, this privilege to us in express terms, and that's simply not the case. We do have all of these amendments, and these amendments pertain to voting. But if you're familiar with the Constitution, you know that they are phrased in the negative. So they also do not contain any affirmative right to vote. So just to give a quick overview of these amendments here, the 14th Amendment, of which we could spend the entire hour just talking about the importance and significance of the 14th Amendment. It contains the Equal Protection Clause, which is immensely important and is the source of the Supreme Court's acknowledgement that the right to vote is fundamental. But the Equal Protection Clause, by its terms, just prohibits states from depriving us of equal protection under the law. It doesn't, again, affirm anything about the right to vote. The 15th Amendment, which was ratified in the wake of the Civil War, immensely important as well, but it's phrased in the negative. It prohibits denial of the right to vote on account of race, color, or previous condition of servitude. The 19th Amendment, it contains the same language as the 15th, but prohibits, again, denying the right to vote on account of sex. The 24th Amendment does the same, right? Prohibits denial of the right to vote on the account of failure to pay a poll tax or any other tax. And the 26th Amendment prohibits denial on account of age for those who are 18 and over. So again, I could say very much about any of these amendments individually or these amendments collectively, but none of them give us the guarantee of the right to vote, right? They don't provide it for us. And so that always raises the question, who then does provide us with that right? Where is that right come from? And the short answer is that it comes from the states. The framers, many of you will know, were particularly concerned about placing too much authority in the federal government. We had just come out, post-Revolutionary War from underneath the British monarchy. And so when they were designing our government and our constitutional system, they were worried about placing too much power in the hands of the federal government. And so they left an enormous amount of discretion to the states. And that's certainly true in the context of elections and voting as well. Now, I'm going to go through these clauses here. I want to say, I teach constitutional law, and sometimes I think constitutional law professors, they run into problems by putting up a bunch of slides that have all these constitutional provisions, which can be dense to understand and difficult to follow. So I promise we are not going to go down a rabbit hole with constitutional provisions. But I do think the background on these two clauses is immensely important to understanding not only the history of voting, but also a lot of the present fights that we're seeing. So let me start with the voter qualifications clause. It's interesting how the framers chose to structure our government. What they told us was that members of Congress are to be chosen by voters possessing the qualifications requisite for electors of the most numerous branch of the state legislature. So in layman's terms, what are they saying here? They're saying, if you are eligible to vote for the most numerous branch of your state legislature, let's just use Arizona as an example here. If you are eligible to vote for a member of the Arizona House of Representatives, right, that's the biggest branch in our state government here, then you are also eligible to vote for members of Congress. So it's a kind of curious scheme they set up here where they connected the right to vote for members of the state legislature with your right to vote for members of Congress as well. But obviously that raises the question, who determines whether you are eligible to vote for a member of the Arizona House? And the answer to that question is, well, Arizona state officials do. Right, the state legislature here and the governor, they are the ones who determine voter qualifications, right? So that's why I think this is worth mentioning and highlighting, because a lot of people have questions about various laws that are passed that are imposing sometimes onerous burdens on individuals to vote. States have the authority, the constitutional authority to pass these laws. Doesn't mean they're all legal and constitutional, but they have the authority to pass them because of the voter qualifications clause in the Constitution. The second relevant clause here is known as the elections clause, and you can see the text of it here. It speaks to the times, places, and manner of holding elections for senators and representatives. and tells us that the time, place, and manner shall be prescribed in each state by the legislature thereof, but the Congress may at any time by law make or alter such regulations. So in practice, this means that states have principal authority, not exclusive authority, because we see that there's a reference to Congress here, but states have principal authority over the regulation of federal elections, elections for senators and representatives. I should say, it goes without saying that states have authority over their own elections. And so what these clauses tell us in combination is that, again, voter qualifications clause gives states authority to determine who's eligible to vote. And then the elections clause gives states principal authority over how elections are run. And so it's this arrangement, right, that is really, I think, in the background of a lot of the voting related fights that we're seeing today. You can imagine an alternate system, right? A lot of countries around the world, elections are run by, the federal government, right? The federal government just runs elections entirely. That is obviously not our system. And so, although Congress has a lot of authority that it could use under the elections clause, and again, if you've been following the news and you've been reading about HR 1, the big federal voting rights bill that's pending in Congress, a lot of what is in there would be constitutional if Congress relied on its elections clause authority. But if Congress doesn't, pass that, then again, states retain complete authority over time, place, and manner of holding elections, along with, again, voter qualifications, right? So that background is, again, relevant not only to the present, but also the past. And so I want to, again, go through some of these transformative moments in the history of voting to give a sense about how this has played out over time. Some of this will be familiar to you, but it's useful background in placing us in our current moment. So jumping back to all the way back to the colonial era and early 19th century, kind of pre-constitutional era up through about 1850. Conventional wisdom, I think, for many people is that the right to vote was limited at that time in the colonial era to a small subset of the population, Protestant white men, oftentimes property owners, and that over time, over the course of our nation's history, the electorate has expanded. That story is generally accurate, right? I'm not telling you that story is not correct, but it's actually a bit more complex than that. And I would recommend you, if you're interested in this topic, there is a really outstanding book by a Harvard historian named Alexander Kaysar. The title of the book is easy to remember. It's The Right to Vote. But this remains the best source for getting a sense of the history of voting rights in this country. It's just chock full of very interesting information. And what Kaysar wants to communicate in that book is that the right to vote, it's expanded at times, it's contracted at times, but it's not a linear story that we can tell. It's not just a story of expansion, right? It's always been ebbs and flows. And what he has to say about the colonial era, I always find very interesting. He says, in the colonial era, not everywhere, but in certain places, you had Catholics voting, you had Jews voting, you had Native Americans voting, you had some free blacks voting, you had some non-citizens voting. You even had some propertied widows voting in various places. I think he talks about New Jersey, where women were voting, in the late 1700s, and then it's only later where we see this retrenchment and this constriction on the size of the electorate. So again, it's a more complex, kind of interesting story once we dig into the history. And the way that states chose to restrict the electorate or shrink the size of the electorate was there were a lot of devices used. But three of the most common were tax-paying requirements, poll taxes, and literacy tests. You might ask, why these particular measures? They're not pulled out of thin air entirely. So the idea behind tax-paying requirements, don't get me wrong, part of their purpose was to limit the size of the electorate. The states knew what they were doing in this regard. But they were looking for justifications for these requirements as well. So for tax-paying requirements, they said, look, it's important that you have an investment in the community, right? And if you are a taxpayer, then you are invested in the community. that's the least we can ask of you if you are going to be a voter in this state or in this community. Poll taxes, the logic was similar, right? It was, how burdensome is it really to pay a quarter, pay 50 cents? As time went on, it was $1.50. How burdensome is it to pay that small amount in order to vote, right? That demonstrates that you're invested and that you care. And with literacy tests, of course, the idea was we want an electorate that's literate and well-versed in things, and we need to test that out and make sure that we don't, we have people voting who know what's happening. So those were the ideas. And to go back to the voter qualifications clause, right, that is what allowed states to pass these regulations, right, and pass these requirements, impose these requirements. Moving into the Civil War era and then the ultimate ratification of the 15th Amendment in 1870, took the Civil War, right, for us to get not only the 15th Amendment, but also the 14th. I'm highlighting the 15th here. And the 15th, again, this is what in theory, gave Black men, not women, but Black men, equal constitutional voting status. Now, I say in theory, because even though the 15th Amendment was added to the Constitution in 1870, it was not enforced, right? And it took the Voting Rights Act of 1965 for Blacks in any meaningful number to be able to vote. That doesn't mean the 15th Amendment's not significant. It's significant for a variety of reasons, but it's just to say that it was not enforced for 90 years. And so it's another moment where we see, this is, we could talk about this theme as well, is just the disconnect between what the amendments actually protect and what's actually happening on the ground, right? That's another highlight, I think, of Kesar's book, is identifying that disconnect. But nonetheless, another transformative moment here. On war, I would also say, and again, I'm relying on Kesar here as well. One of the interesting things about his book is he points out how the electorate consistently expands either during or in the wake of a war. This is true for several wars that he talks about. Certainly the Civil War, World War I, World War II. And when you think about it, it's not that surprising. States are trying to get people to enlist. They're trying to get people to support the war effort. And so one way that they did that was to provide them with the right to vote, or incentivize them, say, look, if you serve in the military, then you will be awarded the right to vote. There also were issues of equity and fairness, right? I mean, how fair is it? How equitable is it to have people sacrificing on behalf of the nation if they are not able to participate in voting? So that is, this is the era, 1850 to 1900, we see this contraction, we see the Civil War, we see, Black persons in theory, Black men in theory given the right to vote, but it's not enforced. The 19th Amendment, ratified in 1920. This is when most people think of this, they think this is what gave women the right to vote. In one sense, that's true, but again, the amendment is phrased in the negative. This was a decades-long push on the part of women to achieve this victory. The history of this, again, is very complex. As I noted before, women in some cases were actually voting even in the colonial era. And what's also interesting is that women, even prior to the ratification of the 19th Amendment, were voting in many places. They were voting with some consistency in Western states. So Wyoming, Colorado, Utah, Idaho, these were places that had granted women the right to vote. When I teach my election law course, I always ask students, why do you think that the right to vote for women kind of started out west and then gradually moved to the east? I get a variety of answers, variety of guesses, but the short answer is that men were trying to entice women to move west. They were looking for a way to expand the size of the populations out there. In some cases, these were territories seeking statehood. And so they thought we can incentivize women to come west by providing them with the right to vote. They were rare in the region. There are other interesting theories about how life on the plains and life on ranches and such were more equitable in some ways because there was sharing of responsibilities and duties. And so women were kind of treated as social equals in a way in the West. out west in a way that they weren't out east. So that kind of lent itself to affording them political rights as well. So again, just another example of how it's not a linear process, right? It's a process that's got contraction and retrenchment and then advancements and such, but all very fascinating. Voting Rights Act of 1965. This is, the crown jewel of the civil rights movement. This changed American politics forever. We have Lyndon B. Johnson here speaking with Martin Luther King Jr. Johnson, interesting individual. I mean, there's much that could be said about Johnson. If you're familiar with the history of Lyndon Johnson, you know that he was not racially progressive for much of his career. Yet between the signing of the Civil Rights Act of 1964 and the Voting Rights Act of 1965, he has this, well-deserved legacy, right, for advancing social justice and racial equity more than any other president, and I think that there's interesting conversations that arise about, whether Johnson was inclined to sign this law or whether he needed to be pushed by civil rights activists in the civil rights movement. I think there's value in having those conversations, but I think the either or framing is a bit misleading. I think that undoubtedly the civil rights movement is a necessary prerequisite to this change, but there are a lot of other variables that factor in as well, including the fact that tens of millions of Americans were seeing on television for the first time Black people being brutalized, and public opinion was shifting. It's also true that Congress, the makeup of Congress was favorable. It was a supermajority of Democrats in Congress at that time. So Johnson, who of course had served in the Senate and had relationships that he could leverage, had opportunities to make change that subsequent presidents may not have. But the Voting Rights Act, does many, many things, but it banned literacy tests, and it led to the skyrocketing of Black voter participation. Black voter participation and registration was dismal in much of the country, but particularly in the South at this time, single digits in some places. And it's only with the passage of the Voting Rights Act that, the federal government is putting its muscle behind political equality, and we're seeing Black voter registration skyrocket. This is also the era of the Warren Court. This is when Earl Warren was Chief Justice of the Supreme Court, a liberal Supreme Court. And a number of interesting developments are happening on that front. The Supreme Court is getting in what Justice Felix Frankfurter called the political thicket, and deciding the famous one person, one vote cases, whereby electoral districts have to have, the same number of persons in them, or roughly the same number of persons. Earl Warren would later say that was the most significant series of cases that he worked on in his time on the court. This is a Chief Justice that was on the court during Brown versus Board of Education and other cases, but he thought the one person, one vote cases were the most important cases of his time. It was during this time that the Supreme Court designated the right to vote a fundamental right. That language has constitutional significance. What it means in brief is that if the right to vote is infringed, then courts are going to take a kind of sharper look at the regulation and really ask states, can they really justify the regulation since it's alleged to have infringed upon a fundamental right. So again, these are just kind of the highlights, and each of these transformative moments they're rich in detail in their own way and really kind of deserve their own treatment. But the upshot is that we've had this expansion of the electorate. We now have various prohibitions on denying or abridging people's right to vote on certain bases or on the basis of certain traits like race or sex. But the clauses that I mentioned earlier are obviously still part of the Constitution. And so states retain the authority not only, again, to set voter qualifications, but to regulate the time, place, and manner of elections as well. I'm going to move on, and I actually want to talk about a case that is pending in the U.S. Supreme Court right now, an Arizona case. But I think this might actually be a good time to maybe pause and take on any questions we might have.
Perfect. Thank you so much, Dr. Sellers. And we do have 4 questions, and I'm actually going to read them backwards in the order they came, since we have couple through the historical lens. So from Tim, they're asking, did the Voting Rights Act of 1965 shift the popular thought from state-based voting regulation to a voting as federal mindset? Or has that been a constant misunderstanding, thinking of voting as a constitutional right?
So it undoubtedly shifted, as I said, it brought the muscle of the federal government behind voting rights. And it contains two key provisions. So let me just speak briefly about, or I should say at the time that it was passed, it contained two key provisions. One of them has been effectively nullified, but the two key provisions at the time that it was enacted were Section 5. And Section 5 is really this remarkable provision that required certain jurisdictions, certain states, to get federal pre-clearance is the term that was used, basically federal permission, before they made any voting related changes, right? And so the idea was that case by case litigation, you see actually a quote on the screen here from the South Carolina v. Katzenbach case. Case by case litigation was inadequate, right? It was too slow, it was too resource intensive. You would combat one form of regulation, states would pass another type of regulation. So pre-clearance, again, required these jurisdictions to get permission before they did anything. That provision is no longer operative after a 2013 Supreme Court case called Shelby County versus Holder. So if you are familiar with the Shelby County case, it's often criticized because it effectively did away with the pre-clearance regime. And Chief Justice Roberts, who authored the decision in that case, seemed to be of the view, and he said this expressly, look, the South has changed, right? He was of the view that enough time had passed that we don't have the same concerns we had in 1965, right? We don't have the same worry about states passing these onerous voting regulations and such that are targeted at certain populations or make it harder to vote. That was a naive view on his part. And we've seen that over and over again. And it's not coincidental that, this rash of legislation we're seeing now, people are referring to it as Jim Crow 2.0. And so that's the fate of Section 5. It could be reenacted by Congress. There is a bill named after the late John Lewis that would do that. But again, that would require congressional action. The other key provision, which still survives the Voting Rights Act, is Section 2. And that provides a right of action, right? It provides a basis for individuals to challenge. This actually will be a nice lead into the case I want to talk about. Section 2 of the Voting Rights Act allows people to challenge electoral regulations that have a disparate impact on minority voters. That still remains. That applies nationwide. It's not limited in the way that Section 5 was. But again, it requires case-by-case litigation, and it can be resource and time intensive. And so it's a very important provision, but it's not, it doesn't have it doesn't place the burden on jurisdictions to get permission first before they do things.
Thank you, Dr. Sellers. And we have a question from Shannon. They say the Catholic Church was very influential in New Mexico with allowing women to vote. Was it the same in Arizona? Also, were there restrictions for voting for Blacks and Hispanics?
So I don't know the answer to the first part of the question. I suspect that's true, but I'm not positive about the Catholic Church's role in Arizona historically. Were there restrictions on Blacks and Hispanics voting here? Yes, there were. And former Chief Justice William Rehnquist was involved personally at the time that he lived in Arizona, was involved in some of these efforts. I think this is fairly well known, but what we're seeing now, it has traces in the past, right? It resembles what occurred in the past. And so there have always been concerns over, obviously preserving the integrity of the vote is very important, but the question is always, are these regulations that are being enacted necessary? Who is going to be burdened by them, and can the state justify what it's doing? So there was a history of discrimination in the state. Arizona, parts of Arizona were subject to the pre-clearance regime that I mentioned before. And the Voting Rights Act, I believe, is 1975. It expanded to encompass language minorities. and additional provisions required, for instance, the issuance of bilingual ballots and such. And so Arizona had failed on some measures and had a low enough percentage of voter participation that it fell within the trigger of Section 5. And so parts of Arizona were covered as well.
Great. Okay. Well, I'm going to go back to Tim's question because they asked that pretty early on. How do bills with unclear language around voting rights resolve issues of interpretation? So how do you resolve issues of interpretation with voting bills? And they do give an example. They're talking about the recent one that just passed, signed by Ducey, SB 1485, with the usage of all in reference who fail to vote an early ballot in all elections for 2 consecutive election cycles. Would that mean you must vote in all or you must vote in one election? But really the question is those issues of interpretation.
Yeah, it's a good question. So with any piece of legislation, there may be questions of interpretation. At times, and I should say courts generally are the ones that will interpret that language in the context of a legal suit, right? So if someone feels that they were unjustly burdened by a law or the law was applied to them, even though it should not have, they have a right to challenge that. And then a court in the context of resolving that will interpret the language. It's also true that legislatures often pass laws that, do contain vagaries, and then it's up to administrative agencies or executive branch officials to explain, right, either through regulation or public statements of some kind, how the law will be enforced. So we'll have to see what happens with this law. It's possible that, say, the Secretary of State might have discretion to interpret the law. But this is something that's arises in the context of any type of vague legislation. There's no special way that we interpret voting rights legislation, although some scholars have suggested that maybe there should be a special way of interpreting democracy-related legislation, such that we put kind of a thumb on the scale, if you will, of expanding participation and allowing more people to vote and such. But to date, no courts have adopted that approach.
Thank you. And we have a question from Gerald, which you might discuss later. They're just asking if you're going to discuss or expand upon HR 1 that you kind of touched on briefly at the beginning of your talk. Is that something you'll address later?
I'm happy to do it. Yeah, let's talk about it at the end. There's we would be remiss if we didn't talk about it. So yeah, let's definitely discuss that, because this is the most significant piece of voting rights legislation since the Voting Rights Act of 1965. And there's much more to it. For as significant and monumental as the Voting Rights Act of 1965 was, that was focused on very particular things, right? Bringing Blacks into the electoral process and opposing the just systemic discrimination that we saw there. HR 1 has got all kind of chapters. So I want to talk about that. Before I do that, I do want to discuss a pending case in the United States Supreme Court. It arises out of Arizona. The caption is Brnovich versus DNC, Democratic National Committee. The opinion will be out sometime in the next 5 or 6 weeks. If you may know, the Supreme Court term ends at the end of June. And so it's common for the high profile opinions to be issued right at the end of June, mid to late June, right before the justices leave town. And so I would not be surprised if that happens with this Brnovich case, although it's possible it could come sooner. But this case involves 2 Arizona laws, one of which requires the rejection of ballots that are there. If you are an in-person voter showing up to vote on election day here in Arizona, there's a precinct that you're assigned to. In most places, there's a precinct you're assigned to. And oftentimes people will go to the wrong precinct and they will cast what's known as a provisional ballot, right? In other words, it's like a temporary ballot that once it's affirmed that you are an eligible voter, then the ballot will be counted. Well, this Arizona law says that if you vote in the wrong precinct, then your ballot will be rejected. It has to be rejected. And so that's the first law. The second law involves, or I should say, prohibits you from having anyone except, there's a short list of exceptions, postal workers, someone who lives in the same household as you. Besides the short list, you cannot give your ballot to anyone else to deliver. This is sometimes colloquially referred to as ballot harvesting. And so lawsuits were brought against both of these laws. Case was filed in federal district court. The federal district court upheld both laws. The case was then appealed to the Ninth Circuit Court of Appeals. And the Ninth Circuit ultimately found both laws to be unlawful. They found both of the laws to be invalid. And they did so because they said the laws have a disparate impact on minority voters. So the out of precinct law, the one that again required rejecting ballots cast in the wrong precinct, they said there's more minority voters who are having their votes rejected because of this law, more minority voters than non-minority voters. And the judge who wrote the opinion said, the state is frequently changing the location of polling places. So this is a contributing factor as to why people are winding up in the wrong precinct. They're changing the location. They're putting precincts, polling places, sometimes in confusing places. And so that's part of why you're seeing this disparate impact on minority voters. So that was a part of the Ninth Circuit saying that law is invalid. Regarding the restriction on, third-party ballot collection, the Ninth Circuit said, look, there are a number of Hispanic voters who live in apartment buildings that do not have outgoing mail service. And so it's not as simple as just, walking down to the bottom of your building and putting your ballot into a mail slot. And this problem is even more pronounced for American Indian voters, many of whom live on tribal lands and they live miles away from a mailbox. And so organizations had been helping these populations by collecting their ballots and then delivering them for them. Again, that's what was invalidated, or I should say that was prohibited by the law, and then the Ninth Circuit invalidated the law. Again, before the United States Supreme Court right now, the expectation based on the oral argument is that the Supreme Court will probably not agree with the Ninth Circuit. The Supreme Court will probably uphold both laws. Again, we'll have to see. But this is significant not only for Arizona, but the case is significant because it's likely to announce a standard by which all sorts of electoral laws will be evaluated. And all these laws we're seeing, coming out of Florida, Georgia, Texas. Someone just mentioned the bill that Governor Ducey signed just yesterday, the day before. They're all going to be subject to the framework that is announced in this Brnovich versus DNC case. So we're watching this case very closely because this is going to give us a sense of how likely future challenges are to succeed. I think that, it's hazardous to venture a guess. Again, the predictions are based on what was heard at the oral argument, and then also the belief expressed by some of the justices in prior opinions that they are skeptical of, finding discrimination just based on what we might think of as, minimal disparities. There was some discussion in the oral argument about there needing to be like a substantial disparity between minority and non-minority voters. Again, hazardous to predict which way the court will take it, but definitely a case that, everyone should keep an eye on. So I did want to, I'll talk about HR 1, but I do always feel like when I give these talks, there's a little kind of pessimism in my delivery or my tone. So I try to end on somewhat of a positive note and just talk about, potential solutions. And actually this will tie in with HR 1 nicely. I think that what's unfortunate about this system where you have jurisdictions just passing laws and then you have lawsuits immediately filed. And then we just wait for courts to decide whether there is intentional discrimination, a disparate impact on minorities, or maybe some general undue burden on voters. That's the pattern that we see in just all of these cases, case after case after case. What's unfortunate about that is I think it prohibits us from thinking in a proactive way, right? And engaging in kind of forward thinking about how can we actually really improve and protect the right to vote. We're always in a kind of reactive posture. instead of thinking in a kind of more forward or experimental way about what's working. We have the benefit of our federal system gives us the benefit of having 50 different states running thousands of elections all over the country, right? We should be looking for best practices. We should be looking for ways that, things that are working in other parts of the country that we might be able to import. Arizona, one of the things to be proud of, right, is that we have such a high percentage of people who are voting by mail, right? Mail-in voting, it was essential last year, but even apart from last year, right? It's preferred by people, public opinion supports it, it eases the voting process, right? This is something that should be expanding, in my view, not contracting. Obviously, protections matter, and we need to protect the integrity of ballots and such, but absent evidence of a real problem, I don't understand why we would be trying to, again, pull back on that. I also think we need more money generally for elections. I just completed a study with a former colleague of mine, and jurisdictions spend very little money on elections. They're short on money. Election officials are constantly telling us that lack of resources is their principal problem. They need to upgrade machines. They need, increasingly to worry about cybersecurity issues. They need more staff. And so we need just generally more money flowing into elections if we want them to be well executed. I think having, competent and professional election administrators is essential. There are a couple of certification programs I'm aware of, but only a couple around the country. I think that's something that should be, looked at more broadly about trying to get, standards in place for election administrators and have kind of ongoing education and updating of stuff, sharing, information sharing and stuff for election administrators. And lastly, I think we need more just public participation in the process, more opportunities for the public to weigh in, give public comment, and describe in their experience, what is working for them, what is not working, what reforms would they like to see. There are opportunities, and you can always call your legislator, right? But I think we need more formalized opportunities for citizen engagement to give feedback to election administrators about what is working for different populations. So that's my closing pitch. I also would say I'm open about even more, more broad reforms, more larger reforms. We are in a position now in this country where we have, minority control in a lot of ways, right? We have gerrymandering, right, which gives a minority oftentimes majority control, right? We have the United States Senate, which is very imbalanced, right, in its design. We have the Electoral College. And so I think we should be thinking more broadly and more capaciously about some of the larger reforms that are discussed in the media as well. It's not to say that majority rule should trump everything. One of the great features of our government is, right, that's not the case, right? Minority views are protected. But when you have a minority of people or elected officials who are representing only a minority of people, entrenching their advantages, right, over a long period of time, that presents a more fundamental challenge to our electoral system. And so that's why I think thinking about the larger reforms becomes important. So let me turn back to you, Julian, for questions. And again, I'll make sure to talk about HR 1 as well.
Thank you so much, Dr. Sellers, for those kind of having that positive note there about potential reforms. We have some questions from Jeannie. They're asking, what law restricts incarcerated persons from voting?
So states are able to prohibit felons or former felons from voting because of a provision in the 14th Amendment. So the simplest way I can explain it is that the 14th Amendment, again, this is coming in the wake of the Civil War, contains a provision that basically says to states, you have to allow people to vote, right? If you don't allow people to vote, then you are not going to be readmitted to the Union. Again, this is the wake of the Civil War. Unless someone engages in a crime. Right. So since that language is in the 14th Amendment, that the Supreme Court told us in 1973, that gives license for states to ban felons from voting. Now, states don't have to, right? And there are efforts that I'm aware of underway here in Arizona to end, that restriction, to allow former felons to vote. I would say there's a related, also important issue about jail-based voting. Right, we're talking about non-felons, just people who are in jail for temporary amount of time, oftentimes held too long, right? So we need effort devoted to jail-based voting also. But in terms of prohibiting felons, the reason that's permitted is because of this one provision in the 14th Amendment and how the Supreme Court interpreted that in 1973.
Great. And we have a question from Mitch. Is there a way to have the Supreme Court revisit its Shelby decision in light of the recent onerous voting laws passed by state legislatures?
So again, the Supreme Court, any court for that matter, resolves cases and controversies. So the Supreme Court can't kind of on its own just say we want to revisit this. It would have to revisit it in the context of an actual dispute. And right now, there's no possibility of that because it has already invalidated the pre-clearance regime. So what would need to happen is that Congress would need to reenact the pre-clearance regime, right, or restore it. And as I said before, there is a law pending, John Lewis, named after the late John Lewis, the Georgia congressman, that would do that. Now, the question remains, right, if this John Lewis Act passes and the pre-clearance regime goes back into effect, and I should say it wouldn't be the identical regime, it would be a kind of updated formula that would be used to identify which jurisdictions had to get their activities pre-cleared. The open question is, how would the Supreme Court treat that? How would it treat the inevitable legal challenge that would come to the revised pre-clearance system? That's hard to know because in the Shelby County case, Chief Justice Roberts seemed to say, basically in the opinion said, the problem with this law is that the formula used to identify the jurisdictions is outdated. So the question is, if Congress updates that formula, does that mean that the court would uphold the revised pre-clearance regime, or would it find some other basis to invalidate it? That's a hard question to answer.
Great, thank you. And Tim has a question, and I think this is going back to the Brnovich case you're just discussing. If the prediction holds true, would that mean the bar to prove discrimination or disparities is now higher and requires near blatant disparaging language?
That's exactly right. The bar would be heightened. That's the concern that many people have, is that the bar would be heightened to a point where it would be very difficult to win cases. Lawyers will know, right? You can bring a variety of challenges to any particular action. You bring a constitutional challenge, the burden of success, it's very hard to win those cases because the burden of proof is very high. In order to win, say, a claim based on intentional discrimination under the Constitution, you have to show not smoking gun evidence, but something akin to smoking gun evidence, right? You have to show that the legislature, they meant to discriminate when they passed this law. That's hard to show. The reason why these claims succeed under the Voting Rights Act is because, again, you can succeed by showing just a disparate impact on minority voters. And then there's a variety of other factors that are considered as well. So it's not just the disparate impact. But the point is, it's much easier to win one of those cases than it is the intentional discrimination case. So the concern many people have with regard to the Brnovich case is that the court will raise that bar, as you said, and make it much harder to show, much harder for plaintiffs to succeed, requiring something more than just a disparate impact or a disparate burden, maybe something like a substantial burden or a material burden or something along those lines. So you described it well. That's precisely the concern that many people have.
Great. And before we dive into HR1, Gerald has another question. I think this might be in regards to when you were talking about reforms in the future and having public participation and discussions about voting. Do you think state legislators are going to be invested in those voter participation discussions?
I would hope so. I mean, ultimately the legislators respond to us, right? They respond to the citizenry. And, I get a lot of questions about various laws that are passed and the sensibility of them. And I always say nothing prohibits the legislature from passing dumb laws, except our involvement, right? And our ability to hold them to account. So, it's a tough question you ask, right? Because we know that there's this interesting dynamic, this complex dynamic between legislators and those they represent, their constituents, right? And sometimes it can be hard to tell, are the legislators following what the public wants, or are they dictating what the public wants? But ultimately, and this is, to many people, an unsatisfactory answer. It requires, public holding legislators to account for the irresponsible things they do, the nonsensical things they do, and to the extent that they are moving out of line or in even anti-democratic ways, they should be challenged on that. They should be required to respond and explain themselves to the public. So that's somewhat of a non-answer, I recognize. I mean, I would hope that legislators would be interested in engaging in those conversations. But the only thing that's really going to, I think, prod them and push them is the public holding them account on election day, right? And them recognizing, like, I have to do X, or that's going to be my job.
Great, and I think that kind of speaks to Ellen's comment in the Q&A about representatives maybe not listening to the people. Thank you. And Dr. Sellers, did we want to kind of go back to HR 1, maybe talk about what it is and its potential impacts?
Sure, yeah. So HR 1 contains, so for those who may not know, this is a big bill that is pending in Congress right now. In many ways, it is I think without question, it is the largest election reform bill in American history. It addresses all sorts of things. And this is separate than the John Lewis bill I mentioned, actually. That is a separate bill. So HR 1 is focused on all sorts of reforms, including opposing partisan gerrymandering by requiring states to create independent redistricting commissions. Here in Arizona, of course, we already have one of those, but many states do not. And so this would require states to create independent redistricting commissions. There are provisions in there pertaining to ethics of members of Congress. There are provisions in there pertaining to campaign finance and the obligation for people to disclose, or nonprofits to disclose and stuff, sources of money. There are provisions in there pertaining to what's known as public financing of elections, right? So there's a matching funds program that would match federal funds for candidates who want to, instead of accepting, the idea is you're not accepting large donations from donors. You are instead taking public money that the government will match, small donations at a rate of 6-to-1. And so there's an enormous amount in there, and that is what have led some people to criticize it. They say there's too much, right? There's too many opportunities for people to attack it and object to it. And what's complicating this, right, is that the Democratic Party controls 50 Senate seats, Republican Party controls 50 Senate seats. And so the success of this bill probably, we don't know exactly what everyone would do once the bill, it's in markup right now in the Senate, but we have to see when it is brought to the floor, and Chuck Schumer said he's bringing it to the floor. This probably turns on what Senator Joe Manchin from West Virginia wants to see happen, and possibly Senator Sinema also here from Arizona. It seems like the ball is in their court in terms of whether this will pass or not. Again, it's hard to predict how legislative dynamics might change. But the key element here is the filibuster, right? So under current Senate rules, you need 60 votes in order to end debate. And in today's political climate, it is virtually impossible to get 60 senators to agree on much of anything. which means that, again, a small minority or a minority of senators can oppose anything and object to anything and hold anything up. And so the dilemma that the Democrats are facing is, do they want to eliminate the filibuster or, reform it such that maybe the filibuster doesn't apply in like voting rights legislation or something like that in order to get this through? Senator Manchin opposes, the Democrats acting unilaterally, and he favors bipartisanship and wants to see bipartisan support for that. Senator Mitch McConnell has already indicated that's not forthcoming. And so it's a bit of a stalemate at the moment, but the consequences could not be higher, right? Because we see this legislation being passed all over the country. We see, again, we are in the one period in a decade when we have redistricting happening also, right? This happens once every 10 years after the census. We just had the census, redistricting's happening. So, the consequences here are pretty much right in our face. And so this is going to be a standoff. And frankly, I really don't know how this will shake out. I mean, Manchin seems pretty firm in his claims about wanting there to be bipartisanship. But, if he's looking out on the landscape and seeing all the things that are happening in the states, then, I don't know if he'll stay on that position or move off of that, but, time will tell.
Thank you, Dr. Sellers. That was very informative. Thank you so much for breaking that down for us. I do want to get to the last question in the Q&A from Tim, who's had a lot of good questions tonight. How can we contend with systemic issues, such as Republican control in a state such as Georgia, when education is gutted, service is removed, and voters disenfranchised? It becomes easy for re-election. Would this be something that can only be addressed via pre-clearance?
Pre-clearance could be part of it on the election side of it. That wouldn't necessarily speak to some of the policy issues that Tim mentioned. But there's a clear relationship there, I should say. That's worth pointing out as well, right? It's the right to vote, is the prerequisite to change on all these other fronts. So when we think about restrictions on voting rights, we should also think about restrictions on all the legislation that, we'd like to see that also can't happen, right? Because the state legislature doesn't reflect the composition of the electorate, and this is really an issue of gerrymandering. And so that's why, again, particularly, I think the provision in HR 1 regarding, the requirement that independent redistricting commissions be created is important. And it's not just, by the way, that independent redistricting commissions would be created. It also, the way that HR 1 is written right now, it contains, limits on how skewed the resulting districts could be, right? So there are like empirical measures built into the bill that would prohibit states from, constructing districts in a way that would greatly advantage one political party over the other. And so that's an important part of this also, because you have, 50% of the state voting for Republicans, you would expect that roughly 50% of the legislators would be Republican as well. When we have great divisions, say 40% voting Republican, but they have 60% of the seats, then we have a problem with representative democracy. So anyway, pre-clearance could be part of the resolution. I also think we can't, minimize the importance of just, being involved and being aware and being active. I mean, Stacey Abrams in Georgia has done incredible work, right, in getting people organized and getting people out to vote. And one of the, I think, underreported on aspects of these bills that we're seeing all over the country is that it's not entirely clear how in the long term they will affect the electorate, right? So I think many of the legislators seem to be of the view that these laws will necessarily benefit the Republican Party at the expense of the Democratic Party, and that it will be largely Democratic-leaning voters who are affected by these laws. But that's not entirely clear. And so there's a possibility that these laws could disadvantage their own voters, actually, and make it harder for their own voters to participate. At the end of the day, partisanship aside, I mean, what is important is just having as many people participate as possible, right? wherever that leads politically is wherever that leads. But I think, to me, the fundamental problem is, all of these concerted efforts to, again, try to restrict and limit the right, instead of more creative thinking, again, about how we can expand it and how we can bring more people into the fold. I feel like that's where our attention should be. And instead, we're constantly just, again, reacting to all these laws that's clearly are intended to just make it more difficult. The bureaucracy of this, is also an important part of this. Just having, again, as I mentioned before, election administrators who are people of integrity, responsible, and who take their job seriously. They are the unsung heroes of our decentralized election system. And so, governors get a lot of attention, secretaries of state get a lot of attention, but it's the folks on the front lines, oftentimes the county officials, the county recorders, right, the poll workers. They are an immensely important part of this. And so that's where I would like to see more resources and attention devoted to that level of the electoral system.
Thank you so much, Dr. Sellers, for that wonderful response and for joining us tonight and for your talk. It was extremely informative. And also thank you to our audience for the excellent questions. This was a wonderful program. I do want to just say to the audience that we have a survey that will pop up when you leave the webinar. It's a quick 4-question multiple choice survey that should only take you about 20 seconds to take. So if you do have some time after you leave and you can complete that, that would be excellent. And I also want to make a quick plug for our upcoming programs in this series. We'll be talking about county recorders, as Dr. Sellers was saying. We will be talking to former Maricopa County Recorder Adrian Fontes next Wednesday, and he'll be talking about the voting process and the voter experience in Arizona. And then we'll have Daniel Allen on with us 2 weeks from now, May 26th, 6 p.m. On that, so Wednesday. She'll be talking about civic participation in a digital world. So definitely check out those programs if you haven't already registered. Thank you so much again, Dr. Sellers, for joining us tonight. And thank you everyone for taking some time in your evening to learn more about how we can be civically engaged and why voting matters.
Thanks so much.